Good morning. This is Jamie Mertz, Managing Broker at Virtual Properties Realty. And today we're going to be talking about the RE forms, the contract for purchase and sale of real property. We're going to go through the RE 100 purchase and sale form, and we're going to explain real quickly how you can complete this contract. You're going to go ahead and start the very top of the contract with the offer date. That's today's date, the date that you're making the offer on the property. And then you're going to fill in the following lines. It's going to be asking for who the contract is made by and between. You're going to put the buyer's name and the seller's name. If you're representing the buyer and you don't know the seller's name, you can find the seller's name located on the tax records. Otherwise, you are welcome to leave that part blank, but do fill in your buyer's name. Then you'll want to go down and read the next line and make sure that you understand that this contract incorporates the reference of those certain terms for the purchase and sale of Georgia property published by Orthis Real Estate Enterprises at www.reformsga.com. You want to make sure that your clients receives a copy of those standard terms for purchase and sale. That's form number RE1. They do have it in English, Korean, Spanish, and Vietnamese now. So please provide your client with a copy of those forms when giving them this contract to sign. They can also locate those forms at reformsga.com. We'll proceed down to paragraph 1, property description. You need to describe the property that you are selling. The best thing is to make sure you list the property address. So you're going to check the first box where it says property address and fill in the address that you're selling. If that's 123 Main Street, that's the property you're going to fill in that address right there. In addition, we would like it if you would include a legal description. Legal descriptions can be located on the tax records. They can also be found in the gsccca.org website. It is best that you include 2 forms of property identification. However, on the RE contract, a property address is sufficient. When you proceed down to paragraph 2, purchase price, you will see that it asks you to spell out the purchase price of the property. This is the price you're offering to purchase the property for. So if you're offering $150,000, you're going to write out $150,000, and then you're going to put the numeric value $150,000. Paragraph 3 is earnest money. This is your buyer's good faith deposit. You're going to spell out how much in dollars they're giving, $1,000, $1,500, $2,000. You're going to spell that out, and then you're going to write the numeric value in paragraph 3, as well as completing who the earnest money shall be made payable to. That can be made payable to the listing brokerage, the seller's brokerage, or a closing attorney. Those are the 3 sources that can hold earnest money that are recommended. So again, you're going to put the name of the firm that's going to be holding the earnest money, the amount of the earnest money, and then you're going to check how that earnest money is being provided. Keep in mind, the contract gives you the option for cash. That is not an option for earnest money to be delivered. It can be a personal check, a starter check, certified funds, or a money order. And then you're going to state whether that earnest money is being deposited today, meaning at the time of the contract being signed by the buyer, they are giving you that earnest money check. If they are not physically giving you that earnest money check, then in paragraph 3.1, you should check box 2 where it says buyer has not remitted and provide the number of days that the buyer will be providing that earnest money. I recommend within 3 days of binding agreement date. Now, make sure your buyer and you understand that if you put 3 days there, that is due to the holder by that 3rd day. That does not mean that you are picking up the earnest money on the 3rd day and delivering it to the holder on the 4th day. If your buyer is out of town and you need to incorporate mailing days or overnighting days, keep those numbers in your mind when completing this section. At the bottom of page 1, please have your buyer initial the bottom of the contract. If you are the seller, make sure your seller initials the bottom of the contract as well. When you proceed to page 2, paragraph 4 talks about the closing. This is the date the transaction shall close on. You're going to fill in that date, and then you're going to say where it's going to close at. Closings in Georgia are handled at an attorney's office. So you're going to put at the office of and fill in our closing attorney's name and location. Most closing attorneys have multiple locations, so you'll want to specify which location you're closing in so all parties know where to send documentation to. If the closing attorney is unavailable or unacceptable to buyer's lender, since the closing attorney represents the buyer's lender, then who shall have the right to select a different closing attorney? The default right there would be buyer, is who you would be filling in. And that section right there is buyer. And then you need to check when the possession is going to be granted. At closing or how many days after closing. You need to specify the number of days. 1 day, 2 days, 5 days after closing, and the time. 3 p.m., 5 p.m., 8 p.m. So everybody understands when the possession is being granted. Paragraph 5, closing cost allowance for buyer. This states that shall contribute a maximum of a certain percentage or a dollar value towards closing costs associated with buyer's purchase of the property. This is what the seller is going to pay on behalf of the buyer towards their closing costs at closing. 1%, 2%, 3%, $1,000, $2,000, $3,000. Make sure that if you choose a percentage option, you check the box in front of the percent, or if you choose the dollar value, you check the box in front of it. That box is not checked, but the numbers are filled in. They're not a party to this transaction. So please make sure you check the box correlating with whether you want percentage or dollar value. Paragraph 6 is our contingency paragraph. This is where we talk about finance contingencies, appraisal contingencies, and buyer's general right to terminate, or maybe you know it as a buyer's due diligence period. You need to check all of them that apply. Again, this falls into that default. If you don't check the box, but you fill in the date, it's not a part of the transaction. So in paragraph 6.1, buyer's general right to terminate, this is your buyer's due diligence period. You're going to check that box, and then you're going to fill in the number of days that buyer has for the buyer's general right to terminate. 5 days, 7 days, 10 days. Usually don't go beyond 12 days, but that's between the buyer and the seller to negotiate. Paragraph 6.2 talks about your appraisal contingency. This is the period of time you have for the lender to complete the appraisal and for the property to appraise. Appraisal contingency is usually less than your financing contingency. You're going to be looking at 14, 21, max 24 days in this particular paragraph. And then finally, paragraph 6.3 is your financing contingency. This is the period of time that the buyer has to obtain their financing in the transaction. You don't want it to exceed 30 days. It needs to be shorter than your closing date, but longer than your appraisal contingency. If you are doing an FHA or VA, you need to make sure that you do attach the separate FHA or VA exhibit to this particular contract. Paragraph 6.3 continues on that if you are selecting a finance contingency, that you go in and fill the paragraph below. First, mortgage loan proceeds. You need to check that box that it's contingent upon buyer obtaining a first mortgage loan, and then you need to talk about the type of loan that they're getting. Either put in the dollar amount of the loan or the percentage of the purchase price that's being amortized over the term of the number of years. For instance, you might say they're getting an 80% mortgage term over 30 years. So that would mean that they're putting 20% down. So you need to check either the dollar value or the percentage, and then you need to fill in the number of years. And then you need to check whether it's a fixed rate or adjustable rate and put that the rate is not to exceed and put in the interest rate that's at par. 5%, 4.5%, something of that nature. If they are getting a second mortgage, very rarely is this the case, but if they are, you'll want to complete that information. This is your finance contingency. On an RE contract, the finance contingency is built into the contract. It is not a separate exhibit, as you will see when doing GAR forms. Paragraph 7 talks about your inspection on the property. This says that the buyer has the right, within reasonable notice to seller, to inspect the property and all improvements located thereon for defects and other issues, including but not limited to air conditioning, electrical, fireplace, heating, lead-based paint, mold, plumbing, radon, roof structure, termites, environmental hazards, and other similar issues at any time and from time to time after the time and date of acceptance of this contract. Normally, you're going to check the box from 9 a.m. to 7 p.m. Very rarely do you fill in the other one. So please, in paragraph 7, make sure you check that box 9 a.m. to 7 p.m., which gives your buyer the right to access the property within reasonable notice to the seller to complete those inspections. You'll go on down and it'll say in that further down in that paragraph, in order to facilitate the inspection of the property, somebody needs to make all required utilities operational. You're going to default back to checking that box that says seller shall make all required utilities. In the event the property is a foreclosure or an REO, the buyer might be required to, but 90% of the time you're going to have a seller doing those items. Please make sure that you have that box checked. Paragraph 7.1, 7.11, and 7.12 talk about where the buyer can determine whether property has been used for methamphetamines or if there's a violent sex offender located nearby. This is the buyer's right to seek and consult any and all available resources concerning the neighborhood conditions affecting the property and is concerned to the buyer. Make sure that they do these research themselves. This information is in the contract. You'll want to point it out so that they can research that. Paragraph 8 talks about your brokerage relationship. If there is a material relationship between you and a member of the contract, whether it be the buyer or the seller, you need to duly note that in paragraph 8.1. Relative, close friend, personal instructor, fiance, husband, wife, mother, brother, son, uncle, cousin, all that information needs to be disclosed in the material relationship section. Paragraph 8.2, buyer's brokerage. If you are representing the buyer, you need to talk about what your relationship is. Are you representing them as a client with a written brokerage agreement, or are you representing them as a customer performing only ministerial acts? If you're doing dual agency, where you're representing both the buyer and the seller under a written brokerage agreement, you'll need to disclose that. And a designated agent is when you and the selling agent both work for the exact same brokerage firm. Then you would be designated agency. You would be a designated agency representing the buyer. They would be a designated agency representing the seller. On the seller's broker side, that's where the seller is going to determine, seller's agent is going to determine what type of relationship they have with the seller. If you are doing a for sale by owner, then you will need to check the box for both sides of this transaction on a for sale by owner. If you're doing the designated agency as indicated above, paragraph 8.4 goes on to tell you to disclose who's representing who is the buyer and which agent's representing who is the seller. And then paragraph 8.5 is a new wire fraud disclaimer. It says no broker in this transaction shall email or otherwise electronically transmit wire instructions to the buyer and seller. Any electronic transmittal of wire instructions purported to be from brokers should be reviewed as potential fraud and treated as such. Buyer and seller acknowledge and agree that use of and or reliance on any wire instructions by that party shall be at its own risk. Buyer and seller further agree to release and forever hold broker harmless from any and all liability that may occur as a result of such use and or reliance. Please make sure that your clients understand that they need to obtain wiring instructions from the closing attorney. Make sure that everybody initials the bottom of page 3. Start of page 4 talks about any of the exhibits that you are attaching to the offer. Again, if you are attaching a legal description, short sales exhibit, FHA exhibit, VA exhibit, a lease, how about your seller's property disclosure statement, your HOA information, you need to check the box. If that box is not checked, it is not a party to this transaction. So it's very important that if you're adding any exhibits, you check the box. These are just samples of exhibits. There's lots of other exhibits. Sale, lease of buyer's property contingency exhibit. That you'll want to make sure that any of those exhibits are attached to and made of the contract that pertain. And then you go on further down where you can write in your special stipulations. This might be something where you're going to say the seller's property disclosure statement shall be attached to and made of this part of this contract as Exhibit A and provided within 3 days of binding agreement date. That information is what you're going to be listed here. Perhaps seller's providing a home warranty not to exceed $500. Again, you're going to list that information in the special stipulations. Keep in mind, special stipulations control the contract. Don't overthink them. You're not an attorney. Don't practice to be an attorney. You are an agent. So keep your special stipulations easy to understand for all parties. Make sure everybody initials the bottom of page 4, and then proceed on to page 5. Page 5 gives you a time limit of offer. This is the period of time the offer is open for acceptance till. This is when you're going to give the other party the right to accept that offer till. Usually 24, 48, max 72 hours. You want to make sure you put a date in here. The next line is once it's accepted. And accepted as contract is when the last party receiving the offer has accepted it and properly delivered to the party making the last offer notice that it has been accepted. They will then fill in the offer is hereby accepted. If you have given your clients a copy of the standard terms, a printed copy, you'll want them to initial in this box right here that they have received a printed copy of the standard and terms. That's that RE100 form that I discussed with you at the beginning of this video. And finally, you're going to want to go down and fill in the buyer's information. I recommend buyers sign and provide buyer's printed name. If you're representing the seller, seller's sign and seller's printed name. I do not recommend you add their email address or phone numbers. There's no need for the co-opting agent to know how to reach your client. That is information that only you and your broker need to have. So as long as you've got their name and their signature, that's satisfactory. Then you'll need to go down and make sure that you fill in, whether you're the buyer broker or the seller broker, your information. It will be your brokerage firm, your brokerage code, the brokerage main phone number, 770-495-5050, the brokerage fax number, 770-622-5055. Then you're going to provide your signature, your printed name, your direct phone number, that can be your cell phone, your direct fax number if you have one, an email address to reach you, and you must include your license number. If this information is not all completed in these sides, then it's not a valid contract. You also must include the broker's license number. Okay, so make sure that information is all filled in. If you are doing a for sale by owner, you'll need to make sure that both sides of this is filled in with your information. In a for sale by owner, you might be representing one as a client and one as a customer. And finally, at the bottom, you need to provide the MLS listing number. It's going to be your FMLS number, your Georgia MLS. If it's in both, it's great. If you list both of them right down there, you can provide that by a slash. And then you have everybody initial page 5. That is the completion of the RE100 Purchase and Sales Agreement.